So I was asked to talk about how national judges can get involved in the protection of fundamental rights with the use of the primary ruling procedure. I put together a presentation or a speech which is not a classical academic speech. I want to reflect on a mixture of different things that you might find useful, knowing that this is a training program. So I'm going to talk about past experiences, current experiences, a couple of general knowledge about primary ruling procedures, a couple of things about the law applicable to the enforcement of fundamental rights by national judges, and hopefully this will put together a comprehensive and I think fairly interesting speech on stuff that on matters that I think you are aware of, or you have studied, or you're actually an expert of, which obviously make my task very, very difficult, because you might have a more accurate knowledge than I do on the details of the law on the European Charter of Fundamental Rights. Okay, let's start with a couple of ideas about the preliminary ruling procedure. This is nothing new, nothing too exciting. I just wanted to put together, the basic ideas about this procedural channel. I mean, I think you do understand that in the so-called European Union judicial system, national judges play a very, very important role in the application and enforcement of EU law, very much against their own member states, against their own public authorities. And this is the part of the territorial decentralization of this territorial decentralized system of the application and the enforcement of EU law. National judges are the local agents. Okay, they are the local agents of EU law within the territory of individual member states. And that when national judges engage in this task, they fulfill this task. Enforce and apply EU law in their own national territory. They can rely on the Court of Justice as a very, very special partner. If you want an evidence of how the court sees its own function, what's its own institutional philosophy regarding its participation in the application and enforcement of EU law by national judges through the primary ruling procedure, then it's best to read this little quotation from a judgment from 1981. So basically, the court says that its role when it interprets EU law during the primary ruling procedure is to assist something much larger than the procedure itself, and this much larger thing is the administration of justice in the member states. So you can see from this quotation that the actual role of the Court of Justice is important, but it's also very, very tiny at the same time, considering that the administration of justice in a member state is the bigger thing. I think you've seen, the Court of Justice's general case law on this matter. It has professed a number of occasions that the primary ruling procedure is central to the EU legal order, and also this abstract organizational framework that is called the EU judicial system. I mean, that label comes from Article 19 of the TEU, which defines this collaborative framework of the CJAU, the Court of Justice and national courts, as a judicial system. And I think you also know it from the Court of Justice's jurisprudence that the primary ruling procedure is the guarantee of the so-called uniform and effective application of EU law at a territorial level, so at the level of in the member states, in the territory of the member states. You also know that the Court of Justice understands the limitations of its assistance, of its contribution. So you know that it doesn't have jurisdiction to apply EU law to the case referred to it, to the original case, and we also know that formally it cannot decide on the compatibility of national measures with EU legal obligations. Obviously, there's a bit of irony in my voice because we all know that the Court of Justice regularly reviews national measures in light of EU law, and the Court of Justice makes it very clear that there's a contradiction between the country's EU legal obligations and the national measure in question. It can be a general measure, legislation, or an individual administrative measure. Okay, let's move on to how the procedure works. To this question again, this is very simple, but I think it's there's merit in repeating the basics. So fundamentally, the national judge sitting in domestic, criminal, administrative, civil, whatever case, decides that it needs to rely on the help of the Court of Justice, and then it decides to refer concrete questions more often on the interpretation of certain EU legal provisions, and sometimes or more rarely about the validity of EU legislative measures. Then the Court of Justice delivers a judgment, and in that judgment, it answers these questions. And we all know that the answers given by the Court of Justice are binding on the national judge. And you can see this quotation from Gauweiler, a very important ruling that the binding effect of the Court of Justice interpretation applies primarily to the domestic case, the original case. I mean, this is just a repetition of what happens when the judgment comes back. So when the judgment is rendered by the Court of Justice, the answers come back to the national court. The national court must apply the interpretation provided by the court in the particular case. Now the court has made all these promises in its early jurisprudence, or this is the early jurisprudence, I guess. So it makes the promise that its interpretation is going to be useful for the national court, that it's not going to give an abstract interpretation, for instance, like a domestic constitutional court. It might not get into legal doctrine. Obviously, there's a big variation of CJEU rulings, but the primary aim of the Court of Justice is to give a useful answer, so that the national court will be able to decide the case, the given case, in front of him or in front of her. I mean, these are the promises of the court, and these promises are connected to the fact that the national court is bound to follow the interpretation given in order to decide the national case. Right. I mean, we also know that there are certain limitations of the primary ruling procedure, which national courts, national judges, and even attorneys need to be aware of. So I think it's a very important it's a very important issue that is very often overlooked in legal practice and also in academic analysis of EU legal developments. That the ruling coming back from Luxembourg will be binding on the national court only in certain aspects, and that is the actual interpretation of the rule applicable in the domestic case. Everything else in the primary ruling procedure will not be binding. The assessment of the facts, which is kind of inevitable when the Court of Justice interprets EU law, the interpretation of national law, which again might be inevitable when the court tries to give a useful interpretation to the national judge. These are non-binding on the referring court. I mean, this is a really big challenge. This is the more lawyerish challenge, the most lawyerish challenge perhaps in primary rulings, and also interpreting in general the Court of Justice's judgments delivered in that process. Which parts of the judgments are actually binding, okay, and which parts are obiter, are important for the court's reasoning, but they are not actually the binding elements of the ruling. This is a very much overlooked question. I'm not going to deal with this in this talk. I'm just putting here like a warning sign that that I find the practice of academic lawyers, practicing lawyers, disconcerting. That very often they will argue a clearly obiter part of the Court of Justice as being legally binding on national judges, and also indirectly on national public authorities. Okay, I mean, you're also aware that the usefulness of the Court of Justice's ruling or interpretation will be maybe undermined by a number of factors. You know that the court is sitting in Luxembourg, and it needs to give an interpretation from that geographical position, and its concerns and its understanding might be very different from a judge sitting somewhere in rural Hungary or rural Poland or rural whatever, rural Italy. It might have, these grand ideas, these big systemic ideas about the coherence of EU law as a legal order. I mean, I'm sure you've studied these judgments from the Court of Justice when it, provides these grand declarations about EU law as such. And you also know that that the interpretation can be very, very limited simply because of the very special position of the court and the very special nature of the primary ruling procedure. It's not an appeal court. The Court of Justice is not a court of fact and a court of national law. I mean, if you have seen problematic primary ruling decisions, judgments, you know what I am talking about. That it's very difficult to make sense in the given case of what the Court of Justice wants the national judge to do with the EU legal provision. Okay, and the usefulness of primary rulings can also be affected by the fact that the judgment comes back from Luxembourg, and applying it to the domestic case is an entirely different matter. You have procedural questions, you have questions of domestic substantive law, and there might be other factors which I'm going to touch upon later on in this talk that impede the direct application of the court's interpretation in the case in front of you. And you also know this practice by the Court of Justice that its judgments will defer back to the national court major tasks of assessment of facts and assessment of national law. You know these clauses that the interpretation given by me, okay, should be followed, provided that the national court comes to the same conclusion on the basis of his or her assessment of the facts of the original case or the assessment of the national legal provision. So the court promises to be a useful aid for national judges. However, there are limitations in the system which sometimes make it very, very difficult to rely on the Court of Justice guidance in the most useful manner. Okay, so these were my sort of introductory ideas. So I'd like to move on to these issues on how to use primary ruling procedures for the protection of rights. Again, very, very obvious issues here. I just want to emphasize them again so that you have a deeper understanding. Number one, the procedure can be used in two ways to protect individuals and the rights of individuals. The first way is, perhaps that's the theme of the conference, is to protect individuals from their own member states or the member state in the territory of which they are staying. Protect against national legislation, protect against national administrative decisions, and obviously very often protect against policing practices by public authorities and also the national judiciaries. I think you're aware of this fact that the big majority of primary rulings come from domestic administrative cases, fairly standard procedures in which a private individual or company tries to seek legal protection from an unlawful act of a government body, public authority. The other uses of the primary ruling procedure is to protect individuals from EU measures that violate fundamental rights. This is not very common, but I do think that this is also a core part of the procedure. I mean, very often national governments would refrain from adopting their policies in the national political arena simply because they want to avoid domestic parliamentary scrutiny. They want to avoid domestic political and legal challenges, and take their policies to the European Union level, and make sure that their policy, their controversial policy, is enacted as an EU measure, an EU regulation, and an EU directive, which can have negative effects on individuals in the member states and may violate the rights of these people. So let's not forget about this other important use of the procedure. Okay, again, very evident information, something that you're aware of. The preliminary ruling procedure is not available to secure protection of fundamental rights just in any cases. Okay. Dean Zondervan has already mentioned Article 51.1 of the Charter of Fundamental Rights, which makes it very clear that the protection that you might gain, individuals might gain from EU human rights law, EU fundamental rights law, are limited in the case they challenge national measures. This is also important because it does affect the admissibility of the preliminary ruling. So the national judge might prepare a question for preliminary ruling, sends it over to Luxembourg, and the Luxembourg court refuses to deal with the primary reference on the basis of the fact that following Article 51.1 of the EU Charter, the fundamental rights protected in EU law are not applicable to the case. The case does not involve an element of EU law. I think it's the written law, the positive law is pretty clear. So member states, so protection against member state action on the basis of EU fundamental rights can be invoked when the states act in the implementation of European Union law. This condition applies to EU Charter rights, or rights in the EU Charter, and also to EU fundamental rights as general principles of EU law. So legal provisions that are not embodied formally in the Charter, but follow from this body of EU law, which we call as general principles. I think you're aware of the interpretation of this very important condition in Article 51.1 by the Court of Justice. So basically, EU fundamental rights can be invoked against the member states when they act in the scope of Union law. And if you know the jurisprudence, this is just a basic overview of the jurisprudence. There are basically two scenarios when states act in the scope of EU law. The first scenario is when they act as a so-called agent of EU law. Basically, they transpose or they implement or they enforce the EU legal provision in the very different ways it can be. An EU legal provision can be implemented, enforced, and so on and so forth. And the second case is obviously when our national member states will require an authorization from EU law to introduce a measure. This is a basic free movement internal market case. There's a preliminary prohibition of national measures, but obviously under the derogation clauses or the exception clauses, the states may be able to introduce a national measure, even though it contradicts, let's say, the free movement of persons, but the measure is justified by overwhelming public interest grounds. So there's a very broad range of member state activities that are covered. Okay. I think you can see it on the slide. I don't want to repeat what's on the slide, but you also need to be aware that not every case will warrant the application of EU fundamental rights. EU fundamental rights will not be applicable, cannot be invoked for the defense of the individual in question. Okay, right. Again, Dean Zondervan has mentioned this already. There's a very important added value to the application of EU fundamental rights in national judicial procedures. This pertains to the rights in the EU Charter mainly, which makes it more effective than, let's say, the rights in the ECHR, the European Convention on Human Rights. Again, this is fairly basic law. And I think you're aware of these legal principles. that the application of EU fundamental rights before national courts follows from the supremacy or primacy of EU law and also the direct effect of EU legal provisions. Obviously, not all charter provisions will have direct effect. The general conditions of direct effect will apply to EU charter provisions. They need to be unconditional. They need to be precise, etc. But once they meet these requirements, individuals can rely on them and can invoke them before national procedures. And you also know that. Direct effect also means that national courts can review national measures, individual measures or general measures in light of the directly effective provisions of the charter. Again, this is just a repetition, making sure that that you remember your basic EU law. Okay, now if I still have some time, I'm not sure how am I doing in terms of time. I just want to start a more detailed investigation of certain case studies or certain examples of cases where national courts turn to the European Court of Justice in order to make sure that they can protect the rights of individuals on the basis of rights. Well, in the first case that I'm going to talk about against an EU measure, but later on we'll see examples when they invoked EU fundamental rights against national provisions. I want to look at these examples first to demonstrate, to talk about the thought processes, the strategies followed by national judges, and then I will also use examples to demonstrate the problems national judges face when the judgment comes back from the Court of Justice. Okay, so there's two objectives here. First, to investigate the thought processes, okay, of the national judge when it makes a primary reference, and second, to investigate the problems that emerge even after the national judge managed to secure a judgment from the EU Court of Justice. Right, so the first case here is something that I think it's a very famous case. Yeah, you must have studied about it. It's Internationale Handelsgesellschaft, one of the early cases in EU fundamental rights law. I mean, I know that I'm sure that you're aware of the facts of the case, that this is a standard administrative law dispute before a national court. You have a national undertaking, a German undertaking, challenging a measure of a national public authority. This is standard, basic scenario for any kind of application and interpretation of EU law, a good national administrative case, which is somehow connected to the application of EU law. Obviously, in Internationale Handelsgesellschaft, the fundamental rights question arose in connection with an EU measure, and the primary ruling was initiated in order to control the validity, the legality of that EU measure. This is a relevant fact, but I just want to focus on the thought processes of the national judge. So if you read, these are quotations from the actual ruling of the Court of Justice, and you read the text, you understand that the national judge has very reasonable doubts, okay, about the compatibility of the measure with fundamental rights requirements, okay. So the primary ruling stems from this doubt, this idea in the head of the national judge that there's a fundamental rights problem caused by an EU measure, or a fundamental rights problem caused by a national measure. Oh, yes. And I think you do know that in the specific circumstances of the case, the reasonable doubt emerged in the head of the national judge that it was the EU measure that was problematic, and the EU measure that was problematic on the basis of national human rights, national fundamental rights law. Okay, let's move on to the other parts of the thought process of the national judge. If you read the primary reference very carefully, you understand that the German judge had a complex strategy, okay, to challenge the measure on the basis of fundamental rights. First, he challenged the overall framework, okay, so the the main idea, the main purpose, the main objective of the measure. It doesn't matter that in this case we're dealing with an EU measure, or the same strategy could be followed when you have a complex national legislation. You can challenge on the one hand the big objective, the central objective of the measure, and then you can move on to challenge, the very specific provisions, procedural provisions, or detailed substantive provisions in that measure. So you can actually raise doubts about fundamental rights compatibility from two major perspectives. First, the objective, the big scheme of the measure, and then detailed provisions of the challenge legal measure. And if you look into the details of the challenge from the German judge, you can see that it wants the Court of Justice to carry out a fairly basic sort of public law or administrative law scrutiny. Okay, was the measure appropriate to achieve its objective? Okay, was the measure necessary to achieve the objective set out by the lawmaker? And also the question of proportionality. Okay, so nothing really extreme. Reasonable doubt, to develop your strategy, and then in the documentation that you send to the Court of Justice, what you need to indicate is nothing very different that you would carry out as a national judge in a domestic public law case. Okay. I think you also need to be aware that you shouldn't be making mistakes. Okay, so whenever you prepare your questions and you prepare your supporting documents, or if you're an attorney, you're trying to convince the national judge to make a primary reference, you need to make sound and rational claims. Anything else will be rejected by the Court of Justice. And if you're an attorney, might be your anything else, your unsound reasons and questions will be rejected by your national judge. The national judge refusing to turn to the Court of Justice. And you also know that it follows from the purpose of the procedure that the primary ruling procedure is not about grand doctrine or grand theory. The legal question must relate to the specific case, and the answer requested from the Court of Justice must also relate to the specific problems raised. I just want to point out to the highlighted bit in the quotation in the last quotation that it was the applicant of the main proceedings that before the Court of Justice raised an additional claim. Now, you as a national judge and also you as attorney must understand that once the case gets to Luxembourg, the parties to the original case can still influence how the Court of Justice will decide what kind of interpretation it might provide. Yeah, the primary reference, the referring process does not end with the questions being drafted by the national judge drafting the supporting material. The hearing before a Court of Justice may also bear importance, okay? May also bear relevance as to the outcome of the national case. Well, in International Handelsgesellschaft, it was thrown out because the claim by the applicant was thrown out because the Court of Justice found it irrelevant. Okay. Again, something very quick. This is again one of the big traditional cases.
Márton.
Yes.
Márton, sorry to interrupt. Yeah. As you know, we have a delay. So can I ask you to conclude in about 5 minutes?
Yes, I'll do that. Yeah.
Thank you.
Yeah. Right. So let's move on to the more contemporary, problems in more contemporary examples of national judges asking the Court of Justice to assist them in giving protection to individuals on the basis of EU fundamental rights law. I brought to you here 2 Hungarian asylum cases. The first case is one of the famous ones coming from Hungary. And it deals with how national judges, might be able to help individuals against a national policy and legislative background that is highly problematic from the perspective of EU asylum law, the relevant standards of EU fundamental rights law, and also from the perspective of the international law relating to the protection of asylum seekers. The problem was pretty clear. This is the high point of the European migration and asylum crisis, 2015, and the Hungarian government decided to overhaul asylum law in Hungary to make it almost impossible to secure international protection in Hungarian jurisdiction. One of the instruments introduced was the revocation of national courts' rights or judicial powers to reform a negative asylum decision, basically change a negative asylum decision and grant international protection in their own judicial competences. I mean, what happened? I think this is the term used in commentary. Was a game of ping pong. So basically, this is the case of Alexei Torubarov. Said a negative asylum decision, which went to the court, was challenged before a Hungarian court. The Hungarian court found it illegal. Obviously, the Hungarian court had no right to reform the decision, so it had to go back to the asylum authority. The asylum authority delivered again a negative decision, went back to the judicial phase. The court again found it illegal, went back to the asylum authority. The asylum authority again brought a negative decision, which went before the national court again, which was about to find the decision illegal. But instead of delivering a judgment, turned to the Court of Justice and asked about the legality of the Hungarian provision. Yep. And the court decided, as I think expected, if you know your European asylum legislation and Charter of Fundamental Rights, the court made it clear that Hungarian judge has a right to assume jurisdiction to reform the administrative decision and grant international protection. And also the national court was authorized to disregard the very explicit national provision which excluded that judicial power, that power from Hungarian courts. Yep. So you had the judgment coming back. The referring Hungarian court made the decision according to the Court of Justice's reasoning. So it assumed jurisdiction that it doesn't have under Hungarian legislation, and it granted international protection. And as you can see it from the communication from the human rights defenders, human rights lawyers defending Alexei Torubarov, they were satisfied with the result. Okay, so ultimately the primary reference was successful. However, if you look at it from a structural perspective, a primary reference will not guarantee that the state will remedy the legal situation that led to the violation and that led to the national court making a primary reference. Yeah? So practically, you have national judges exercising powers which is contra legem, which is against the explicit provision of national legislation. National judges exercising jurisdiction on the basis, okay, of a very, very short sentence provided by the Court of Justice in a ruling, okay? And you can imagine that this puts pressure on national judges. They were looking for a resolution. They got a response from a Court of Justice, but that response does not deliver the complete resolution of the legal problem, because the complete resolution would require, okay, the national government to decide that national measures need to be modified in light of the Court of Justice's ruling. In contemporary Hungary, there's very limited possibility for that, for the government modifying its restrictive asylum law in light of Court of Justice's reasoning. This is not going to happen. It's unlikely to happen. It's very clear that the government is unprepared to make it happen, which means that national judges will have to decide asylum cases on the basis of an interpretation given by the Court of Justice against, okay, in contradiction of explicit national legal provisions regulating their competencies. I think I need to finish here. I have another very exciting case. Again, I'm not going to go into details because my time is running out. If you have time to look into these cases, I would recommend it very clearly. I just want to say a couple of sentences very briefly. The legal position of the Court of Justice is pretty clear. The Court of Justice gave us a very clear interpretation. However, the Court of Justice's interpretation directly conflicts the previous interpretation of the law by the Hungarian Supreme Court, which interpretation was maintained. Okay, was maintained right after the Court of Justice delivered its own ruling. So you have a situation where you have domestic binding jurisprudence from the highest judicial authority, from the Supreme Court. The Supreme Court being very clear that it wants to maintain its own interpretation. And on the other hand, you have an interpretation coming from another high court, which is the Court of Justice, which contradicts the interpretation of the domestic Supreme Court. And obviously, if you are a lower instance national judge, first instance national judge sitting in asylum cases, that will give you a lot of headaches. How to proceed in such cases. On the one hand, you're bound by the jurisprudence of your own Supreme Court, but then you also need to follow the Court of Justice interpretation, which contradicts that judicial interpretation. So again, you as a national judge or you as an attorney might want some kind of a resolution from a preliminary ruling procedure, but then it's also very clear that sometimes in very specific circumstances, domestic law will prevent you from guaranteeing that resolution. You will be able to grant individual relief, individual remedy in individual cases, but you won't be able to change. You won't be able to change the entire system which has led to the fundamental rights violation. I'll stop here if that's okay. I know I overstepped your patience. Thank you very much. And if you have any questions, I look forward to hearing that later on. Thank you.